Hi, everyone. Thank you for joining us today for Constangy's webinar, Peering into the Crystal Ball, Envisioning the Future of Workplace Accommodations. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat tool at the bottom of your screen in the toolbar. Our presenter will leave time to answer your questions. This program is approved for SHRM and HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow afternoon. Today's presenter is Lara de Leon. Lara is a partner in our Orange County, California and San Antonio offices. She's also the co-chair of the firm's Diversity, Equity, and Inclusion Practice Group. She's an experienced trial lawyer and client advocate. Her extensive career has involved representing companies of all sizes across many industries and all aspects of employment law. Lara has successfully defended clients in the courtroom, before administrative agencies, and on appeal. In addition to litigation, Lara has spent her 2+ decades of experience partnering with clients to counsel them through complex issues involving discrimination, retaliation, accommodation, and wage and hour compliance. Lara has also developed a passion for guiding clients through high-stakes matters involving pay equity, harassment, leave of absence, and accommodations. Lara has had the distinct experience of working as in-house counsel for 2 large multinational corporations, which gives her a unique perspective on how to address the intricate issues facing organizations and their employees. She is also board certified by the Texas Board of Legal Specialization. I am now going to turn it over to today's presenter, Lara.
Wonderful. Thank you so much for that introduction. Hi, everyone. We have a lot of interesting ground to cover today as we talk about the future of workplace accommodations. We've had a lot of development and activity, even just this year alone, in a number of areas that involve workplace accommodations for our employers. We've seen developments in connection with pregnancy-related accommodations, religious accommodations, and we continue to see momentum and action in the context of accommodations for individuals with disabilities. So I'm going to go ahead and just jump right in right now and start talking, because we have a lot of new information, new laws, new cases, new agency actions that we want to talk about. And I want to make sure that we have time to get through them, and also to the end, which is where we'll talk about steps that we should take as employers to help us navigate through some of these new waters. So first, I'm going to talk about pregnancy accommodations. And we have had on the federal landscape 2 new developments in December and early part of 2023 in the form of the Pregnant Workers Fairness Act and the humorously and funnily named Pump Act. And so these are laws that were passed by Congress, kind of snuck into an omnibus appropriations bill, but important nonetheless, that are really groundbreaking from a federal law perspective in providing important rights to our employees who are pregnant or suffer from pregnancy-related medical conditions. I know I'll touch a little bit later, but I know a lot of folks who operate in a number of different states or have likely dealt with the issue of state laws that impose requirements on employers to accommodate pregnant employees. But now it's very important to realize that we have a federal mandate now as well that is being actively enforced by the EEOC. And so we want to make sure we include this in our calculus as we're dealing with these issues, because, shocker, it might have different requirements and different expectations than our state laws do. And while generally speaking, the law that provides the greatest benefit to the employee will prevail, whether that is the state law or federal law, I don't know, there are still some nuances I think that exist that could make it kind of an even tie, in my opinion. So employers will want to definitely pay attention to some of these developments and not just assume that hey, because I'm in California or Oregon or Massachusetts, I don't have to worry about this. I think you are right to worry about it and should certainly pay attention to some of these nuances. So first, just a little bit of level setting. Let's take a trip down memory lane and figure out how we got here first. So back in 1978, Congress passed the Pregnancy Discrimination Act, which was a law that amended Title VII, our national law that addresses discrimination in the workplace. The Pregnancy Discrimination Act basically just redefines or expands upon the definition of sex in that statute. And it says that the term because of sex in Title VII includes but is not limited to because of or on the basis of pregnancy, childbirth, or related medical conditions. So that's all it does. It's basically a definitional statute that clarifies that discrimination on the basis of sex means you can't discriminate on the basis of pregnancy, childbirth, or a related medical condition. It also provides that women affected by pregnancy, childbirth, or a related medical condition shall be treated the same for all employment purposes as others not so afflicted. So this law prohibits discrimination on the basis of current pregnancy, past pregnancy, potential pregnancy, medical conditions related to pregnancy or childbirth, and according to the EEOC regulations, even an individual who has had or is considered to having an abortion. Notably, though, the PDA does not require an employer to provide a reasonable accommodation or any accommodation to an employee who is pregnant. So that was a big gap in our federal landscape. Then fast forward to just 8 years ago, we have a decision coming from the United States Supreme Court where it finally ruled on the issue of what protection does the Pregnancy Discrimination Act give to employees who are seeking an accommodation. We had the case Young versus UPS. And basically what that case was, Miss Young was a driver for UPS. She became pregnant and requested a light duty position after she was given a lifting restriction by her doctor. She could only lift 20 pounds. The job required 50 pounds. UPS's policy, though, only provided for temporary light duty positions if an employee had an on-the-job injury, had an ADA disability, so a disability under the Americans with Disabilities Act, or if they had a temporary loss of their Department of Transportation certification. So in short, Ms. Young was out of luck. UPS said, we don't have to accommodate you. You don't fall into one of these categories. You need to go out on a leave of absence and then perhaps terminate if you're not able to come back. So her request was denied. She sued. And the employer filed for summary judgment, as all employers do in these types of cases. It won, and then Ms. Young appealed it up to the Supreme Court. The Supreme Court overturned summary judgment for the employer, saying not so much that Ms. Young, not so much that the Pregnancy Discrimination Act requires employers to accommodate. It didn't say that. It said we need to look at this as a discrimination case. We can't discriminate against women who are pregnant. So let's look at how the employer provides light duty to other non-pregnant employees. So the Supreme Court's ruling there said an employee can make out a discrimination claim under the PDA by looking at her own situation and the accommodation that she requested, and looking and comparing herself to non-pregnant employees who are similar in their inability or ability to work, and see how the employer treats them. So if the employer provides light duty accommodations to other employees who are similar in their ability or inability to work as a pregnant employee, it would then be discrimination not to also provide that accommodation to the pregnant employee. So there is an exception to this, and I'm just going to point it out before we move on. An employee, an employer will put forward a policy that says, well, this is the reason why, this is the rationale why we could not accommodate the pregnant employee versus another employee. But an employee can still challenge that employer decision by showing that it imposes a significant burden on pregnant workers and that the employer's legitimate non-discriminatory reasons are not sufficiently strong to justify that burden. It was a creation of a new standard in my opinion, it is still somewhat nebulous. I don't see a lot of cases that really analyze what constitutes such a burden. But at a high level, what the court here is trying to get is to say if you, pregnant employee, can show that this rule has a significant burden on pregnant workers, meaning pregnant workers are impacted negatively more often because of it, then you might have something there and can successfully challenge that policy. It's not quite a disparate impact standard. It's kind of a hybrid in between the two, but there you go. We have this concept of accommodating pregnant employees as a basis for discrimination cases that we existed and that we've been dealing with over the last 7 or 8 years. So that has been our landscape. Now let's get to the Pregnant Workers Fairness Act, which comes out and gives us a different set of rules that we need to provide now to our pregnant workers. So kind of at a glance, it became effective June 27th of this year. So don't panic, there's still time to comply. It applies to all employers with 15 or more employees, just like Title VII does. Now, it covers all issues related to pregnancy, physical or mental, whether we are talking about a complicated pregnancy or an uncomplicated pregnancy, whether it's something that qualifies as a disability or not a disability. It is just applicable to pregnancy and pregnancy-related conditions, irrespective of the severity of those conditions. So that is a very big change from what we've been dealing with. The PWFA requires employers to provide reasonable accommodation for pregnancy. Now, the EEOC has proposed regulations. They are accepting comments until, I believe, October 10th. And as of a couple of weeks ago, they had already received over 6,000 comments, and I'm sure that number has been long since eclipsed. The regulations are pretty intense. We're going to go through a couple aspects of them, and I would suggest they would really broaden the reach of the PWFA, even requiring more protections and more accommodations than we currently are required to provide to employees who have disabilities. So the PWFA, it's kind of like the ADA, but not really like the ADA. It uses a lot of the terminology that we're familiar with in terms of reasonable accommodation, undue hardship, interactive process. It even uses this term qualified individuals, but there are some differences with that. So as an initial matter, it requires that employers provide reasonable accommodations for the known limitations resulting from an employee's pregnancy-related condition, and childbirth, right? So we have this concept of it has to be a known limitation. The employee needs to make us aware that there is an issue with work that needs to be accommodated. Now, conditions that must be accommodated, you might be asking yourself, well, what the heck is a pregnancy-related condition? Well, a pregnancy-related condition can be quite broad. And as I mentioned, it can cover common conditions like morning sickness, leg cramps, general nausea, things that are considered kind of mild and are pretty common throughout pregnancy, all the way to conditions that are more significant. And I will talk about those just a little bit later. The qualified individual component, this is what is very different. So, under the ADA and the terminology that we're used to seeing as an employee is qualified if they are able to perform the essential functions of their job with or without reasonable accommodation. That definition still applies here. So a pregnant employee is still considered qualified if, because of her pregnancy or pregnancy-related condition, she is unable to perform the essential functions of the job with or without reasonable accommodation. But wait, there's more. There is another aspect of a qualified individual, which is not similar. And this, I'm going to read you the definition, but basically what it says is the employee does not have to be able to perform the essential functions of their job. They can be unable to perform the essential functions of their job, period, end of story, end of statement, and you would still have to see what you could do to accommodate them. It kind of takes out that qualifying language. So the second prong that is so different and expansive applies to an employee or applicant who cannot perform one or more of the essential functions of their job, period. Where the individual is unable to perform those essential functions for a temporary period of time, or is expected to be able to perform the essential function in the near future. And the inability to perform the essential functions can be reasonably accommodated. I personally had to read this through a few times before I understood it or felt like I began to understand it. But what this basically means is, let's say you have an employee who is pregnant. Let's say you have Miss Young, whose job required her to lift 50 pounds. She was a delivery driver, so it's not like anyone could go along with her and help her lift this. So she had to lift 50 pounds. Because of her pregnancy, she could only lift 20 pounds. She can't perform an essential function of her job. However, this is a temporary issue, and in the near future, meaning after she has her baby, she will be able to perform those essential functions again. So in that case, she would need to be accommodated because her inability to perform the essential function is only temporary and will be over in the near future. So just kind of ponder that. We'll need, I'll just say, just ponder that. It is a big expansion from the position that we're used to being in when we're trying to assess reasonable accommodations for employee. All right, so the undue hardship concept remains, meaning employers do not have to provide a reasonable accommodation if it would result in an undue hardship. So we have the same definition there. And then we also have the same notion of employers need to engage in an interactive process with the employee in order to try to determine what sort of accommodation we're going to provide. So prohibited acts by the Pregnant Workers Fairness Act, a lot of these are going to resonate with you, be very similar, and employers cannot refuse to make a reasonable accommodation absent an undue hardship. Employers cannot require an employee to accept a reasonable accommodation. So you can't, if it, it's all kind of part of that give and take. We still have this notion of an employee doesn't have to always get their preferred accommodation, but you can't give an employee an ultimatum saying you have to take this precise accommodation. Cannot deny an employment opportunity to a qualified individual, whether that's an employee or an applicant. You cannot require an employee to take a leave of absence. That is another thing. And we've had some case law on this up to this point, but the statute now makes that very clear. You cannot take an adverse action because an employee or applicant requested an accommodation or availed themselves of a reasonable accommodation, can't retaliate against an employee or interfere with their rights. So we have some language, some guidance that we've been given about what potential accommodations could exist under the PWFA. So common examples that are given in the statute, and we're also seeing in the regulations, are things such as eating accommodations, letting a pregnant employee bring a snack with them or have a bottle of water with them, give them modified seating if they need a stool to sit down in certain times, provide a closer parking space to the facility so they don't have to walk too far, giving them additional break time to rest, eat, or use the bathroom, giving them flexible hours, providing leave or time off to recover from childbirth. And I'll just put a note here. So this leave as an accommodation, similar to the ADA, would apply even if the employee does not qualify for leave under the FMLA or any applicable state law. So you don't have the 1 year requirement, the hours requirement. So an employee could be eligible for leave as an accommodation on day one of employment under the PWFA. Other potential accommodations are excusing them from strenuous activities, or activities that involve them exposure to compounds that are not safe from pregnancy. I would just make a little footnote here. You have to strike the balance between being overly protective and paternalistic for the employee and providing them with a reasonable accommodation. Don't assume that the employee, just because they're pregnant, can't engage in an activity or be around a certain environment simply because of that. You want to ensure that you engage with the employee, or the employee initiates that request, and you have that dialogue from that point. The other side of the double-edged sword is that employers can get into trouble from a discrimination perspective, right? By assuming that the employee is unable to perform certain jobs. So we have to kind of keep that balance. Rounding out this list, other potential accommodations could be job reassignment, assistance with manual labor. And then I love how they added this to the list because apparently it's a thing, providing appropriately sized uniforms and safety apparel to accommodate the changes that their bodies experience. There is a limited defense under the PWFA, kind of similar to the ADA, where an employer can avoid compensatory and punitive damages for failing to provide an accommodation, where it shows that it made a good faith effort in consultation with the employee. So basically, if it shows it engaged in the interactive process and good faith, and that of course is an issue of fact, but if it shows that, then it can have a defense to compensatory and punitive damages there. So let's talk about the EEOC proposed regulations. These are fun. These are a doozy. I've enjoyed looking at them because I think the EEOC went big on some of these regulations. So first off, they provide a non-exhaustive list of conditions that will be covered if related to pregnancy. And I just have to read some of this list because it's a lot. So the regulations non-exhaustive list of what would be a condition covered if related to pregnancy include the termination of a pregnancy, including by miscarriage, stillbirth, or abortion, infertility, fertility treatment, lactation and conditions related to lactation, the use of birth control, menstrual cycles, postpartum depression, anxiety or psychosis, vaginal bleeding, preeclampsia, pelvic prolapse, preterm labor, ectopic pregnancy, gestational diabetes, cesarean or perineal wound infection, maternal cardiometabolic disease, endometriosis, changes in hormone levels, and many other conditions. And I don't mean to sound facetious with it, but why I love this definition is it basically describes anything any woman over the age of 13 will experience at some point in their life, up to and including the time they hit menopause. So it is an extraordinarily broad definition. I applaud them for their ambition. So we shall see how the final regulations come out and what ultimately makes the cut on this list. My concern as an employer is how do you deal with all of that? Like, that's a lot. Like, does this mean someone comes in and goes like, I have really bad menstrual cramps, I need to stay home today? If I'm wearing a very broad hat and an expansive mind, that would be covered potentially by this. I think that's a little bit beyond the intent of the statute, but I'm just pointing out like the ambition that is shown in some of these regulations. With respect to the qualified individual, remember that second definition that said an employee could still be qualified even if they can't do the essential functions of the job, as long as their inability to do so is temporary or could be overcome in the near future. The regulations would define that term as 40 weeks. So basically, the duration of an average pregnancy is how they would propose doing that. And then there are some other aspects with reasonable accommodations. But the other thing I want to talk about too is that the regulations also come up with what they call a list of predictable assessments, meaning accommodations that are almost always going to be reasonable and that would not require documentation to support that. So some of these predictable assessments, which the regulations say employers should grant in virtually all cases and will rarely constitute an undue hardship, include allowing an employee to carry water or to drink in the work area, allowing additional restroom breaks, allowing an employee whose work requires standing or sitting and vice versa, and then allowing additional breaks to go eat and drink. This sort of echoes a couple of state laws that I've seen that just say, hey, there are just certain kinds of accommodations you're going to have to provide to pregnant people. You don't even have to have a discussion about them. She needs to go to the bathroom, let her go to the bathroom. She needs additional water or additional snack time, give her that. So this is more of that kind of mentality that we don't need to make a whole big deal over certain types of accommodations there. So something to think about. I, again, am super curious to see how these regulations pan out. Implications of all this. I think, depending on how the regulations go, and certainly with the requirement now to provide accommodations to pregnancy-related conditions, I think we're definitely going to see and have a firmer footing to say if other conditions like infertility, for example, are something that would need to be accommodated in the workplace. Now, we already have had that to a certain degree because infertility is considered a disability under the ADA already, because it substantially limits the major life activity of reproduction. But in the context of the Pregnant Worker Fairness Act, I think it could be qualify for coverage under that too. So in that case, remember, we've got these two prongs of qualified. So infertility, it could have a lot of implications on how we handle accommodations for infertility. I like to talk about surrogacy when I talk about pregnancy, issues involving maternal care and pregnancy in the workplace, because I've actually started to see a couple of laws or cases involving people who are involved in a surrogacy relationship, whether they're the surrogate or they utilize a surrogate, and how our current workplace laws affect that. I think the PWFA would not make any distinction over whether it's a surrogacy relationship or not. What we're looking at is the pregnancy situation and what happens and where that, well, I don't want to get off on too much of a tangent on this, but it's a kind of a non-traditional situation that I think we probably have to think twice a little bit. And then we have menopause, and I throw that out there, not just because of the very expansive definition that I read you from the proposed regulations from the EEOC, but because there's a lot of dialogue out there that I've seen in articles and online about menopause in the workplace. And as an aging female myself, it is a topic of interest. But, I think it will be interesting to see, how and whether, employers are going to start having to address issues with employees saying they've got medical conditions or limitations as a result of that change in life. So just kind of throwing it out there as a provocative idea. Obviously, there's no case law on this point, but I think it is a potential outgrowth at some point of some of these changes that we're seeing. So let's not forget, even though we're talking about the Pregnant Worker Fairness Act and what that requires, let's not forget other workplace laws that also apply or could apply to pregnancy in the workplace. You have the FMLA, the Family Medical Leave Act, or applicable state law. I did see a comment or a question asking about, would there be overlap? And absolutely, there would be overlap, I would think, the same way that our other current laws, to the extent they allow concurrent use of FMLA, if you're getting leave as an accommodation under PWFA, that and the employee is also eligible for leave under the FMLA, that would run concurrently. I would say, though, and not to get too much in the weeds, there are some state laws like California, for example, that specifically provides that its pregnancy disability leave does not run concurrent with other types of leave. So you want to be very cognizant of that. But generally, at a high level, at a federal level, certainly you would get concurrent running of that time. So just remember that FMLA grants up to 12 weeks of leave, either on an intermittent or full block leave basis for pregnancy and pregnancy-related conditions, as well as the birth of a child. So we don't want to forget that that's out there too. The ADA, pregnancy is not a disability under the ADA. However, certain pregnancy-related conditions, if severe enough, can rise to the level of a disability. And in that instance, would be eligible to be accommodated under the ADA, just like any other disability would. We know that the PWFA goes broader than that, right? But there's still that kind of backstop with the ADA. And then, of course, we have state laws. There are about 18, maybe a little bit more, state laws that specifically require employers to accommodate employees who are pregnant or who have a pregnancy-related medical condition. And all of those vary greatly in terms of expectations on the employer, interactive process, what is required, what is not. I've mentioned California, I think Washington, Oregon, Massachusetts jump out at me. South Carolina, I think, too, is having unique provisions there. So obviously, you always want to check the state in which you operate, too, and add that to the mix as you're dealing with these situations. So let's transfer over to the second new law addressing pregnancy or related condition, and that is the Pump for Nursing Mothers Act. And that actually is an acronym for Providing Urgent Maternal Protections for Nursing Mothers Act. I think that's very clever, actually. So what that does, that the Pump Act, it came into being in December of 2022. It became enforceable in April of 2023. What that does is it expands the lactation accommodation provisions of the 2010 Nursing Mothers Act. So the 2010 Nursing Mothers Act is a component of the Fair Labor Standards Act. It's kind of a very weird place to kind of bake in this law, but it basically said non-exempt employees are entitled to receive break time, unpaid break time, in order to pump their breast milk. It also provided that employers needed to provide an adequate space in order to allow women to do this. The space needed to be in a private area, not a bathroom, that had accommodations for maintaining like a refrigerator or something like that for a woman to store the breast milk after she pumps. So there were some gaps with that. The first gap was that it applied only to non-exempt employees. But now we have, with the Pump Act, exempt employees are clearly covered by it. So it applies to all employers of all sizes, as long as they're covered by the FLSA, which is pretty much anybody engaged in interstate commerce. There are limited exceptions like airlines, but by and large, most employers are now covered by this. It clarified that the break time is allowed every time the employee needs to pump. So you can't just say, we provide 2 rest breaks during the day in addition to a lunch break, you need to use those. If the woman needs to pump 5 times a day, then under this law, you would need to make a schedule and allow the woman to pump 5 times a day. The break time is unpaid unless they're not completely relieved of duty. So if they're working while they're pumping, and it happens, it can very easily happen, if they're working, they get paid. If they're not working, they don't get paid. Now, note, if you're talking about an exempt level employee, they get paid anyway, right? Because they're paid on a salary basis. So unpaid, unless they're not completely relieved of duty. Now, the new law has a provision in there that says that before an employee can file suit, she has to give the employer an opportunity to correct the issue. So she's required to inform the employer that has not provided an adequate place and give the employer 10 calendar days to correct the issue and to come up with compliant facilities. The only situation where this 10-day heads up would not apply is if the woman was fired, for utilizing a lactation break. She doesn't need to go through that, but she can't sue saying, hey, you didn't provide me with a clean sanitary room, until she's giving you notice and time to change. So that is something to definitely be aware of, and something that we act quickly on. In addition, the law makes clear that there are damages available for noncompliance. So an employee can recover or can get reinstated if she's been retaliated against. She can get promoted if she's been denied a promotion. She's lost wages, she can get that. There are liquidated damages, attorney's fees and costs. So there are damages available for noncompliance with the Pump Act. So a couple additional considerations to keep in mind with lactation issues, because this existed before the Pump Act. There could be state laws that provide more requirements. Usually the requirements apply to things like the configuration of the mother's room. What sort of things do you need to provide rather than just a private space? Does it have to have an electrical outlet? Do you need a refrigerator? Does it need a sink? Things like that. How many do you need per square footage? That sort of thing. So be aware of your state law with respect to providing mother's rooms. And then we do still see some case law. Now, granted, this is older case law before statutory protections came into play, where they found that discriminating against a woman because of her lactation status can give rise to a claim for pregnancy or gender discrimination. And there are some very interesting cases. And I mean that in all earnestness. They are really interesting cases that address those theories as well. So let's shift over to religious accommodations. And the big issue with religious accommodations is back in June, the Supreme Court issued a decision in the Groff versus DeJoy matter. And that's a case against the post office, where the Supreme Court pretty much overturned 50 years of precedence and gave us a new standard for how to evaluate requests for accommodation on the basis of religion or religious belief. So let me tell you a little bit about that case. So the employee in that case was worked for the post office, delivering packages and mail, and originally worked in a very rural part of the country. Groff was an evangelical Christian who believed that he should devote Sundays to worship and rest. And so he asked not to work on Sundays. Originally, or I guess initially, he was allowed to do that. He transferred to a different location where Sunday deliveries weren't required, and all was well and good in the world. And then the post office started working with Amazon and delivering for Amazon, and that required Sunday work. So the employee refused to deliver packages on Sunday because it was inconsistent with his religious beliefs. The employee was ultimately disciplined for that and was forced to resign. So it was a constructive discharge situation. The employer said that this isn't a reasonable accommodation to exempt him from this Sunday requirement because this is a new business requirement. We have to work on Sundays. It would create an undue hardship because it would diminish morale among the ranks. Because other employees would have to work on Sundays too. And it would just create an intense scheduling nightmare, particularly since this guy worked in a rural place. So the employer won summary judgment, actually. And honestly, that's not a surprise why. I'll go into it in a second. The prior standard for assessing a reasonable accommodation under Title VII for religion was super low. It was this de minimis standard. And those of you who lived through COVID and the vaccine stuff, which I'll talk about in a second, know that we were talking about the differences in the undue hardship standard between religion and disability, right? So there's a really, really, really low bar under religious accommodation standards up until this point in time. So the employer won, right? Because it was a de minimis burden to them. The employer won, the employee appealed. We get all the way up to the Supreme Court. And the Supreme Court says, you know what, guys, we were wrong. There's no such thing as a de minimis standard. I'm paraphrasing. They didn't really say this. But both parties actually argued that the de minimis standard was wrong. So it's just they differed on what the new standard should be, right? But what the court said is that what is most important is that the undue hardship in Title VII means what it says, okay? So it says de minimis doesn't show up anywhere in Title VII. De minimis showed up in a Supreme Court case from 50 years ago. So it got rid of the de minimis cost accommodation issue, replaced it with a requirement that employers now must show the accommodation would result in undue hardship. That is a substantial increased cost in relation to the conduct of the operation. Okay, meaning that we need to look at the employer's operations, i.e., it's going to be case specific, case by case, fact specific issue, and it must result in substantial increased costs. So that is the new standard for higher standard for an undue hardship. An employer must show that to accommodate the employee, it would not going to just simply result in employee morale or a scheduling nightmare or an inconvenience, but a substantial increased cost. So before, de minimis, very small or trifling, employers won all the time. Now, substantial burden, meaning substantial additional costs, substantial expenditures in the context of the business, much, much, much higher standard. So what are the near-term implications of this? I mean, this stuff is going to obviously work its way through the courts and has already. I've already seen quite a few cases already citing this decision. So number one, in my crystal ball, probably not unique in this, we are going to see or should anticipate seeing an influx of religious accommodation requests from employees. All right. I think over the past 3 years, especially with vaccine issues, and I just think generally we're seeing a lot more requests and voiced requests from employees about work rules that are conflicting with their religious beliefs. There's definitely been an increase. I mean, that's all I can say from my practice. We're going to see employees seeking certain days off, Saturday, Sunday, for religious observances. We've seen that for decades. We had a plan in place on how to address them. I think that plan in place might need to be revisited. You know, we used to say, hey, go find someone to swap with you. It's all good, or certain things like that. The standard is different now. So it warrants looking at that again, I think. Grooming standards. There's a case, I was just looking at this Hebrew versus Texas Department of Criminal Justice case. It's a Fifth Circuit case that actually just came out a week and a half ago, dealt with an employee who was a member of the Hebrew nation, which is different than Judaism, by the way. But as part of his religion, he took a vow to keep his hair and beard long, and that violated the company's grooming standards. And the Fifth Circuit just reversed summary judgment in favor of the employer and sending it back down. So the employee gets to continue on with his case because he said the grooming standards conflicted with his religious beliefs. And so he gets his chance now to try that case in court. There's also another case recently that the EEOC just sued another company a couple weeks ago. Again, an employee was Muslim and wore a beard as required for his religious beliefs. And the company said, oh no, we've got grooming standards. We need to be clean cut. We can't have long hair. It's, for perception and customer service and safety. Yeah, we don't want people pulling on hair. And the EEOC is out there, the forefront of this, saying this is religious discrimination. How can you show this is a substantial burden to allow this employee to maintain these grooming standards? Safety policies, vaccines, flu vaccine, COVID vaccine, still with us. I put DEI up there with a question mark, diversity, equity, and inclusion. This is more of a provocative question, although I have seen some anecdotal news stories about this, where employees are saying that compliance with corporate DE&I initiatives conflicts with their religious beliefs. Just saying, it's out there, could evolve into something, I don't know. So yeah, we're going to see a lot of religious accommodation requests that must be taken seriously. Not that they weren't taken seriously before, but they must be taken seriously in light of this new burden that employers have when they want to deny an accommodation, right? I mentioned the COVID hangover. So we just can't escape it. Recall back in the day, 3 years ago, where there were mandatory vaccine policies. And there was a lot of discussion, a lot of time was spent on maneuvering through those vaccines requirements and the exceptions and the accommodation requests due to disability and religious concerns. Now, I'm going to say within the past couple months, especially in light of this Groff decision, we are seeing, the EEOC was always very interested in that, right? There are a lot of charges in the pipeline dealing with religious discrimination and COVID vaccines. So those are always in the pipeline. And the EEOC did have an interest. I'm saying, though, now is in the last week, the EEOC has filed 2 lawsuits against employers resulting from their vaccine mandates during COVID and the employer's refusal to accommodate an employee due to their religious faith. So you can look on the EEOC website if you're interested in those, but 2 in the past week. So I think that is just an indication of more to come with respect to that. So take heed, certainly with religious requests for religious accommodations. I have some suggestions at the end on how to deal with it, but this is definitely an area that we are going to see more and more and more of come up, and simply addressing them the way we're used to addressing them with this de minimis standard in mind is not going to pass muster anymore. So there's a question here I want to just point out before I move on to disability accommodation. And the question was, is the religious accommodation still valid if an employee was hired with the understanding that the work schedule required Sunday work? I mean, that does kind of raise a question, right? The employee was to say, knew that Sunday work was a requirement. Here's the thing, is that religion is kind of, I'm not going to say fluid, but religious beliefs change. And, we could say, well, when we hired you, you knew this was a requirement. However, an employee could say, yeah, but back then that was fine. Now I'm a part of this new church, or I have this new belief, or I have deepened my faith, and it now conflicts with that faith. That would not excuse you from having to interact with the employee and consider whether and what kind of accommodation you can provide. So I don't think it completely absolves you, especially if the employee has new information that they present that says, this is a different situation or a new circumstance. They weren't, pulling one over on you or anything like that. So it is complicated. I mean, no doubt it is a complicated situation. All right, so shifting gears to disability accommodations. What I was hoping to do with this particular section is just identify a couple of trends that we're seeing, and in terms of case law and EEOC activity in the field of accommodations. The first thing I wanted to point out was telework as an accommodation. Y'all remember, again, this is kind of another COVID hangover. And a lot of us were kind of wondering, with all of the remote working that was successfully done during the COVID era back in 2000 to probably 2021, and even still ongoing, what now is an employer to do if it wants to insist on employees coming back to work, but now we're faced with accommodation requests by an employee saying, I need to work because of my disability or whatever, I need to work from home. And initially the EEOC, I recall, had said temporarily providing telework due to the COVID pandemic was not going to mean that now all of a sudden you have to consider telework as an accommodation for everybody. Because remember, before COVID, telework was kind of a boogeyman, right? It was like, oh my gosh, we need everybody at work. Everyone has to be at work. And that was such a much stronger feeling than it is now, because we've experienced what we've experienced. But now, as workforces are coming back to work, it's like, well, now what do we do? Is there a basis to say telework now is 100% a reasonable accommodation, because we've shown that it's a reasonable accommodation during the COVID era? So first off, in the accommodation world, nothing is 100%, right? There's nothing that's absolutely a disability. There's nothing that's, always going to be required to be an accommodation. It's very case specific. But this report from Bloomberg Law, and this just came out in July, as an article from Bloomberg Law, they evaluated court rulings on telework as a disability accommodation, and they looked at it from pre-pandemic to post-pandemic. And how are the courts evaluating these reasonable accommodation cases? And you can see here the top level from 2017 to 2019, the majority, I think it's like 70% of the court cases, or what they called pro-employer, where they said providing telework is not a reasonable accommodation. But then looking at the case law since the pandemic, so in the last 2 years, you can see that has shifted now, where we're seeing a lot more employee favorable rulings saying that telework is a reasonable accommodation. And no doubt the employee in that instance is saying, hey, I successfully did this during the pandemic, so you can't say it's an undue hardship now, or it's difficult to show that it's unreasonable or would be an undue hardship. So anyway, I thought that was a very interesting study that was done about telework. There's also another case out of the Fifth Circuit, which is over Texas, Louisiana, and probably a couple other states that are escaping me right now, that said remote work can be a reasonable accommodation. And why that is interesting is the Fifth Circuit is usually a very conservative circuit, tends to be more employer friendly, although I've kind of seen that shift a little bit depending on what panel you get. But generally speaking, they are as conservative as the Ninth Circuit is liberal. So, for them to come up with a decision that seemingly favors employees is kind of, a harbinger of maybe things to come. But in that case, and this is the Montague case, for those of you who are interested, the plaintiff was worked as a communication program specialist. And they had this peripheral neuropathy, which made it basically hard for them to get up and moving in the morning. And so their request was, hey, can I just work from home in the morning while I'm, getting going? And then I'll come to work in the afternoon. This request was denied, saying that travel around and physical presence in the office for the entire workday was an essential function of the job. Anyway, long story short, the court did not find that argument very availing, particularly in light of the fact that the employee had done the job successfully on a remote basis before, and that another coworker and the past incumbent on the job were allowed to telework on a full-time or part-time basis. So you kind of get bit in the butt, honestly, if you do this for some and not for others. But there you have it. That's the status of telework as an accommodation. And then kind of going to the EEOC, they have been super active lately, filing lawsuits. And I don't know how I got on this list, but I get like an alert every time the EEOC sues someone. But there are a lot of lawsuits filed over the past couple months on many bases, but in particularly with respect to accommodations. And I've just summarized a couple of them here. A lot of them are dealing with, the first one deals with a nurse who was injured on the job, has temporary lifting restrictions. And the employer said, no, we can't accommodate you. You're a nurse. You've got to be able to lift. And the EEOC, and she was ultimately fired because she couldn't come to work. And the EEOC is suing the company, alleging that they terminated her, one, but two, they did not provide her with a reasonable accommodation. The other one dealt with a EEOC suing a hotel for refusing to accommodate and then firing an employee who wanted to sit at a stool and limit walking. This person had a musculoskeletal impairment, and they worked at the front desk, and they asked to have a stool every now and then if they could limit walking. And the hotel said, no, you can't sit because that is unprofessional. And, sitting and stools are one of those areas where I think their claims that an employer cannot provide a place to sit or a stool are being met with a healthy dose of skepticism. It's very hard for courts or juries even to get their head around, well, why can't you just give somebody a stool to sit down every now and then if they need that assistance? I mean, in certain jobs, I get it. Some jobs don't lend themselves to that, but especially customer service jobs, why don't you let them sit? But I digress. Oops, I didn't want to go past that. Well, let me round up. You can see the other cases here all about failing to accommodate. There's one involving working from home. Another one involves providing sign language interpreters. So let's talk about moving forward. These are the money slides, guys. So what do we do? Always have to tell you, update your policies and procedures, but I honest to goodness mean it this time. These are significant changes to your policies that involve dealing with how are we going to deal with requests for accommodation? How are we going to evaluate these requests for accommodation? And when you have these processes, we need you to document them so we can defend you when you get sued, right? So update your policies and procedures. Address the unique aspects of pregnancy accommodations. And I'll talk about religious accommodations next. I would include in your policies a process for raising complaints about lactation spaces. Remember, the employee must give you 10 days to correct a situation if they think your facilities are deficient. Put that in your policy. And then ensure your interactive process is conducted on a timely fashion. I say that because there was something in the proposed regulations about the timing of the interactive process in connection with pregnancy discrimination or pregnancy accommodations. Even to the extent that some you don't necessarily need to require medical documentation supporting it. If it's a relatively minor ask and the employee's pregnant, don't require the employee to go to the doctor and get a note and bring it back and do all that stuff. So ensure that you're handling these on an appropriately timely basis. Get ahead of the issues. You know that some of these issues are going to be coming. So I would suggest, these are just my suggestions, put together a template break plan for employees who need the lactation breaks. You know, employees, we now know that like, hey, managers are going to be fielding these requests. I need multiple breaks. Well, help your managers, give them a tool to say, hey, this is how we can schedule breaks. Think ahead on that issue so you're not left scratching your head and causing delays when an employee actually has that request. Ensure the availability of appropriate spaces for lactation breaks. Get with your facilities people. And then consider what short-term accommodations you can provide now. I always have to tell you guys to train your folks. It is time to re-educate managers in HR with respect to expectations and terminology for pregnancy, lactation, and religious accommodation. Take all requests for accommodation seriously. I know you do, but reinforce this with managers, especially if we're so used to kind of making that mental checklist of, yeah, I have to do this. No, I don't have to do that. Given that that's changed, it is time to re-educate and reinforce the notion that we need to take all of these requests very seriously. Review each request, especially for religious accommodations, very carefully, and ensure that if you are going to deny a request, you have done your diligence to evaluate whether you can meet the substantial hardship. And then finally, buckle up for more activity from the EEOC. Their strategic plan specifically calls out issues relating to COVID, to pregnancy, to religious issues. We have a very active EEOC. We are going to continue to see that, and we are still seeing lots and lots and lots of lawsuits from them. So before we go, those of y'all who need your HRCI or SHRM credit, please do write down these codes. I don't want you to miss that. I apologize for not being able to get to your questions. However, we do keep track of them. So we will endeavor to get you a response to those questions. And I really appreciate your attention today. I appreciate you coming to this webinar and supporting us this way. But with that, have a great rest of your day, and we will now end the webinar.